What are the common problems when you have a visa interview? Now, specifically when you're abroad, okay? There's some things that hopefully, if you have not had the interview, for better or worse, one thing you need to expect, at least one. Of course, I have so many to share. We're here to solve immigration problems. We do offer free 15-minute preliminary discussion. We do share a secret code so that you can unlock those free 15 minutes. And we like to share that towards the end of the show, of course. I have a better perspective on this, like the common problems, more so because of that we accept mandamus cases, that we help clients file a lawsuit against the government when there's a delay. And the thing is that there's delays for many reasons. Okay, one thing is that you want people have filed or provided a DS 5535. So I'm talking about this because you might not receive an official 221G type notice on the same day of interview or even the day after. They might just go straight to this and say, you need to provide this form. This is what it looks like. It's annoying. It's 3 pages. Look at that address. Oh my goodness. They want to know your address for the last 15 years. Really? Is that really necessary? All your phone numbers for the last 5 years. All your email addresses for the last 5 years. They want to know your spam email, I guess. All your social media, employment, where you worked for the last 15 years, and you sign it on third page three. They want to know your relatives, your siblings, whether they're full sibling, full blooded, half step, or adopted, living or passed away, deceased. It is pretty freaking ridiculous. Okay. Why the heck do the government want to know that? Well, I can tell you what I'm speculating why the government wants to know this. It's because maybe if you have a family member, who knows, maybe they could have smuggled someone in. I don't know, whatever they want to allege. But we have received calls about people who said that their dad was did some bad things and they're not involved with his shenanigans. And so that maybe that's why they want to do this, to delay. But at the end of the day, it's to delay, okay? Because we've had people we had to file a lawsuit when it's been at least 4 months after you provide this document. And people that call us, they're pretty quick. They give this document as soon as possible. In fact, we've been advising our own clients to fill out this form beforehand, just in case. So you just have it ready. It's just another reason delay. And why would you we should not let the government take advantage of the fact like, hey, by the way, I actually have the form that you might ask about. So back off, buddy. Okay? Just give me the visa. It's pretty ridiculous. So anyway, that is one common problem. Okay? The other common problem, the 221G notice in general. Okay, we have a client that where at the first step they provided all documents about proving their birth. Okay, they have a delayed birth certificate, meaning most people get the birth certificate at the time of birth, but there are scenarios. Maybe if you were born at home or just outside the hospital, you may receive a delayed birth certificate. We use a lot of acronyms, so I'm like thinking acronym at the same time. The government, even though in that situation, for example, USCIS mailed out a request for evidence to provide that proof, and after that's all taken care of and that was approved, the embassy or the consulate, the officer over there for the visa interview, is trying to hash out that same question, and it's ridiculous because it's already been approved. Why do you have to question it? And they're questioning it about the sponsor, the petitioner, the US citizen, not about the applicant. Okay. So that is another common problem. Okay. That is a second one I want to share with you. That is one that is what we call basically where they can send a notice to back to USCIS to say you might want to issue a notice to intent to revoke the petition. That's basically one of our strategies. Essentially, when we sue the government, say, hey, they've already rehashed this out. Why they don't need to do that again? And if they're going to do that, then how come they didn't issue a notice of intent to revoke? Like, stop delaying this. It's again ridiculous. Okay, the third thing is most common problem for visa interview is when people may not have realized that they need a waiver. Okay, if you've been in America without a visa or overstayed your visa, your authorized stay, and you've been living in the United States for more than 1 year, more than 365 days, which probably it's safe to say that it's a lot of people, millions of people that are in this situation, for better or worse. There are options out there, but especially when you hire. I've heard so many stories when people hire like a notario or consultant that does not have a law license, that they don't explain the legal requirement, the need for a waiver. There's a lot of phrasing about this, or different names about waiver, and that is 601A is the form number itself. Okay, provisional family unity waiver. Okay, that's another name. You really need to consider this, because we've had people call us that fortunately we were able to prevent them from going, because then they realized after our discussion with our team that we talked about the need for a waiver because of the overstay. Okay, and the other things people call is like unlawful presence. When you overstay, we call it unlawful presence, and you need the 601A, which, by the way, 601A form, the processing time for that is minimum before the pandemic, 8 months. It shows 28 months. 28 months. That is ridiculous. Before pandemic was 8 months. But here's the deal with waivers. We just had a consultation. Our team had a consultation with someone this week about the need to file a waiver, and that they were waiting until there was a serious health condition about their sponsor or their qualifying relative. In this situation, was his parents. And there's a what do you call it, misconception or misunderstanding that waivers require like a medical hardship about your qualifying relative, family member. It does not. That's just one consideration. Okay. There's a lot to discuss about that. The third reason, not being prepared, okay, for the medical exam is not just a visa interview. Sometimes it's a lot of things. It's not just about not being prepared, but it's about possibly sharing too much information, I guess you could say, because a lot of things is not up to the visa officer. Okay, unfortunately, the medical doctor, because when you go abroad, you have to get the medical exam. To explain the steps here: medical exam, biometrics for your fingerprints, and then you have the visa interview. Okay, and so when they get that medical done, they ask questions about your, if you drink alcohol, do you do drugs, and I don't know anything about like timing of taking samples, how that shows up in the test sample, if they do all that, just in general, because I think it feels like there is an obligation to share all that information. It really depends who you're speaking with, right? So you need to speak with a lawyer about that. Here's what I heard what happens, and that is that when a person has gone to medical, get that test result, exam results, just get the exam conducted. I mean, and the doctor says, ask, when's the last time you drank? And what, it's like October right now. Last time someone drank alcohol was in July 4th, right? That makes sense. If you drink, I mean, I would think you drink in July 4th. Also, pretty common. It's a holiday in America. And he said he drank one beer, and the medical clinic used that information against him. Okay. And they said, look, you can't get your visa. Like, why the hell would a medical clinic try to tell this applicant that they can't get the visa just because they drank a beer in July 4th, about 4 months ago? So you want to consider there's so much to know. It's not just about the interview, it's about understanding what information you should share or not share with the medical clinic as well. This person also had like a DWI, 2012, about 10 years ago. So what they're trying to allege basically is this person is an alcoholic, habitual drunkard. Habitual drunkard is a phrase that USCIS uses for naturalization, but the visa officer did not even allege specifically about an ground of inadmissibility related to a health concern, which includes drug abuse and being an alcoholic. And so this clinic said that this person has to have double A, Alcohol Anonymous classes for 8 months. That's a bunch of bull. Okay, so this is a situation where you can file a lawsuit. It's not about, in this situation, it's not necessarily about unreasonable delay. It's more about arbitrary and capricious decision, erroneous decision. Okay. This person was qualified and should have received his visa. Instead, the visa officer basically blindly relied on the physician, the medical clinic's arbitrary decision. It's very unfortunate. So there's a way to fight, and it's called a mandamus lawsuit. So that's three common problems, friends. So if you're new to the channel, we do have on our website free guides, okay? Basically a PDF that has common question answers to common questions, a step by step. Okay, this is one for mandamus lawsuits, so you have a better idea of timing, maybe when to file a lawsuit based on a certain scenario. Yeah, you can go to our website. It's all right there. You don't even have to call us for it. Okay, friends, thank you so much, and have a great day. Bye bye.